Good morning, students. Welcome back to business law class or legal aspects of business. We were seeing second unit Indian Contract Act 1872. Today we'll discuss about chapter 4 consideration. I will be covering definition of consideration, legal rules as to consideration, stranger to contract, and contract without consideration is void. Consideration meaning something in written, or in Latin phrase it means quid pro quo. According to Indian Contract Act 1872, Section 2D defines consideration as when, at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstain from doing, or promises to do, or to abstain from doing something, such act or abstains or promise is called a consideration. It is in a complex sense. I will make it easy for you people. At the desire of the promisor, the promisee either does something or abstain from doing something. The act or abstains is called a consideration for a promise. So it has two major aspects: doing something or not doing something. We'll see an example. Example 1 for doing something. There's a contract between two parties, Peter and John, where Peter promised to deliver 15 curtains to John in 1 month time. John promised to pay Peter amount of 3,000 on delivery. In this contract, John promises to pay 3,000 on delivery is a consideration for Peter's promise, and on point of Peter, delivery of 15 curtains, it is consideration for John's promise to pay. Curtain is consideration for John and 3,000 is consideration for Peter. It's example for doing something. Example 2 for not doing something. Peter has taken loan from his friend John and he has not repaid the loan yet. So John promises that he will not file a suit against Peter if he repays the money within a week. So here, consideration of Peter promise to repay the amount makes John from taking any action. It prevents John from, or abstains on the part of John from taking any action against Peter. I hope you understood. The next one we'll see essentials of valid consideration or legal rules governing consideration. It must always be provided at the desire of the promisor. It means that an act constituting consideration must have been made at the desire or the request of the promisor. It is done at the instance of a third party or without the desire of the promisor. It will not be a good consideration. For example, A saves B's goods from fire without being asked to do so. So A cannot demand payment for his service because consideration must move from the desire of the promisor. If it is not, then it is invalid. Next, we'll see it may move from the promisee or any other person. Consideration may move from promisee or any other person or even a stranger. This means that as long as there is a consideration for promise, it is immaterial who has furnished it. But the stranger to consideration will able to sue only if he is a party to a contract. There is a famous case law, Chinnaya vs. Ramaya 1882. Chinnaya is a plaintiff or affected party. Ramaya is defending party. So, an old lady by deed of gift made over a certain property to her daughter Ramaya, so I'll name it as D, under the direction that she should pay her aunt Chinnaya, I name as B, sister of old lady, a certain sum of money annually. The same day, D, the daughter, enter into an agreement with B to pay her agreed amount. Later, the D refused to pay the amount on the appeal that no consideration has moved from B to D. Held, B was entitled to maintain a suit as a consideration had moved from old lady, sister of B, to the daughter. Next, it may be past, present, or future consideration. Past consideration, when consideration by a party for a present promise was given in the past. Therefore, before the date of promise, it is said to be a past consideration. For example, A rendered some service to B at a latter's desire. After a month, B promises to compensate A service rendered to him. It is a past consideration. A can recover the promised amount. Next one, present or executed consideration. When consideration is given simultaneously with promise, therefore, at the time of promise, it is said to be a present consideration. For example, A receives ₹100 in return for which he promises to deliver certain goods to B. The money A receives which he promises to deliver certain goods to B. The money A receives is a present consideration for the promise he makes to deliver the goods. Next, future or executory consideration. When consideration from one party to other is to pass subsequently to making of the contract, it is future or executory consideration. Take it for example, D promises deliver certain goods to A after a week. A promises to pay the price after the fortnight. The promise of D is supported by the promise of A. The consideration in such is future or executory. Next, consideration need not to be adequate. Consideration already explained, it means something in return. Something in return need not necessarily to be equal to something given. The law simply provides that contract should be supported by consideration. As long as consideration exists, the courts are not concerned as to its adequacy, provided it is of some value. It must be real, lawful, and not illusory. The consideration must be real and not illusory. For example, A owes ₹500 to B. He promises to pay ₹100 to C, a servant of B, whom he return promises to discharge A's from debt. This is legally impossible because C cannot give discharge for a debt due to B, his master. We'll see one more example. A engages B for doing certain work and promises to pay a reasonable sum. There is no recognized method of ascertaining the reasonable remuneration. So the promise is unenforceable as a consideration is uncertain. Next one, it must be something which is promiser is not already bound to do. A promise to do what is already bound to do either by general law or under an existing contract is not a good consideration for any new promise, since it adds nothing to pre-existing legal or contractual obligation. Likewise, a promise to perform a public duty by a public servant is not a consideration. Promise by which the promiser does not gain anything in return is not enforceable. Here it means that likewise the promisee is not also file a case against a promiser where he has not incurred a loss or determinant. For example, there was a promise to contribute some money for renovating a mosque. But the promiser failed to fulfill his promise. A secretary of mosque, who was the promisee, filed a suit, and suit was dismissed on two grounds. The promiser did not gain anything in return, and number two, promisee did not suffer any detriment or loss due to the promiser failure to contribute. We'll see next one. Where the promisee has incurred a liability on the strength of promise made by the promiser, he can sue. See, for example, I'm a construction. I want to start a construction, so I'm going and making a contract with a builder. And I give a promise to him, start doing my construction work, I'll make the payment later. So the promise which made by me makes him to incur liability once he started the construction work. So what liability the promise he has incurred for starting the business, for starting the work, whatever the loss he has incurred for my default payment, he can sue. Next one, act constituting consideration must not be illegal, immoral, or opposed to public policy. Here it means that suppose there are two persons indulging in an illegal activity, whatever the consideration is coming out of that, it is void.